60. And I will ask the reviser to please give us a bill brief. Thank you.
Thank you, Madam Chair. Senate Bill 60 prohibits second and successive motions and ineffective counsel claims and habeas corpus actions, and it also provides for direct appeal to the Supreme Court and habeas actions that are filed by an inmate who's been sentenced to death. Section 1 amends KSA 60-1507, that's our habeas corpus statute. Current law there in subsection C deals with successive motions, and it provides that the court shall not be required to entertain a second or successive motion for similar relief on behalf of the same prisoner. This bill would remove that provision and replace it with a provision stating that the court shall not consider a second or successive motion unless either the claim relies on a new rule of constitutional law that was made retroactive to apply to this inmate, or two, the factual basis of the claim could not have been discovered and would be sufficient to establish by clear and convincing evidence that no reasonable fact finder would have found the prisoner guilty. There's a provision that's also added that a second or successive motion shall not be filed while an appeal is pending on a motion previously filed or during the time within which such appeal may be perfected. And finally, a motion is a second motion if it raises issues that could have been raised in previous motions, and a motion is successive if it raises issues that were previously raised in a motion filed under this section. Subsection D is amended to provide that if an appeal is taken on a motion filed by a prisoner who's been sentenced to death, then that appeal shall be taken directly to the Supreme Court. Subsection G is added to provide that the ineffectiveness of counsel during a previous action under this section shall not be a ground for relief in a subsequent action unless that claim alleged that the ineffectiveness of counsel completely foreclosed the prisoner's ability to appeal or seek discretionary review by an appellate court. Section 2 amends KSA 60-2102. This is the statute that provides appeal to the Supreme Court as a matter of right. Subsection B is amended to provide that appellate jurisdiction of the Supreme Court can be invoked by appeal as a matter of right from a final decision of the district court in a habeas corpus action if the prisoner had been sentenced to death. And I can take any questions.
Thank you. Committee, questions? Not seeing any, then we'll hear from our conferees. We do have several conferees wishing to testify today, so we're going to limit everyone's testimony to 6 minutes. So 6 minutes, and I will hold up the folder as a 1-minute warning when you've got 1 minute remaining so that we can have opportunity for everyone to be heard. So with that, then, we will invite proponent conferee Chris Elsliger, Deputy Solicitor General, Office of the Attorney General. Please introduce yourself and welcome to committee.
Thank you, Senator Warren and members of the committee. My name is Chris Elsliger. I am the Deputy Solicitor General for the Attorney General's Office. I've been there for almost 25 years, and I have dealt with habeas corpus actions both in the federal and state courts, and so I'm quite knowledgeable on this subject. The purpose of this bill is to stop or stem the kind of tidal wave or the overwhelming amount of repetitive, unmeritorious post-conviction motions that we've seen really over the last couple of decades that stem back to a Kansas Supreme Court decision. What's important to understand is that this bill does not affect any convicted offender's right to seek that first 1507 relief, that first habeas corpus relief. This doesn't affect any of that. It doesn't affect their right to direct appeal. They have a trial, they got a direct appeal. If that gets affirmed, then they can file a 1507 habeas corpus motion in the district court, again, raising whatever issues they want to, usually ineffective assistance of trial counsel. That will get appealed, and this bill only affects what comes after that, which is the filing of second and successive motions over and over and over again. These motions bog down our court system. They take up the judicial resources, they take up prosecutorial resources, they take up defense resources, and they almost never have any kind of merit, but we still have to have hearings on them, we still have to write answers to them, they still get appealed. and we want to put an end to that. And so the First Amendment in subsection C, that really just codifies already the existing rules and procedures. It just does it a little more forcefully and explains specifically the exceptions where you can to file a second successive motion, because we're all concerned about, well, what about the one guy who really does have a valid claim? Well, we have the exceptions there, and those exceptions mirror federal law. A lot of this language was taken straight from the federal law on habeas corpus, so it is well settled, it is well tested, and it works. The real crux of the bill, though, is subsection G, which addresses the root cause of this ongoing cycle of motions. And this comes from a 2004 Kansas Supreme Court case where they inferred a right to effective assistance of counsel in these post-conviction proceedings. Prior to that, for the first 150 years or so, roughly, of Kansas history, there was no such right. There is no such right in the federal courts. The federal courts have repeatedly noted that since there's no constitutional right in post-conviction and civil proceedings, the ineffective assistance in of counsel in those proceedings is not a basis for relief. But in this case of Brown v. State, the Kansas Supreme Court created its own law. And they created a statutory right to counsel in these cases. So that's not there is, if you look in the statutes, there is no right to counsel, to effective assistance of counsel in the statute. This body, the Kansas Legislature, never put that into law. The Kansas Supreme Court created that from that case. And ever since then, we have seen it's essentially a perpetual motion machine. As soon as a guy files his 1507, it goes up on appeal, he loses, he files another one and says, well, the only reason I lost that one is because my attorney was no good. And then that goes through the process, and he gets to the end and he could file another one. This is the only reason I lost that one is because that attorney was no good. And it can go on and on and on and on. And we can certainly look ahead and know that that's going to happen in the capital cases, and they will never end. There needs to be some finality to this. And the federal law has done that. They clearly state in statute that the ineffective assistance of post-conviction counsel is not a ground for relief. And that reflects United States Supreme Court precedent, and it really reflects what was the law in Kansas up until 2004. So the Attorney General supports this bill because this would really return the law to what it was pre-2004. And I would point out that there is in the bill a carve-out to address the very problem that happened in Brown. And if you read Brown, you can kind of understand why the Supreme Court went there, because the attorney in Brown just completely abandoned his client. He didn't do anything. And so the client lost his chance to appeal. So there is a carve-out in the bill to protect those types of very egregious instances of ineffective assistance of counsel. This bill just ends the practice of just essentially just saying, well, the last guy just didn't argue it good enough, so I want another bite of the apple. And the last guy didn't argue it well enough, so I want another bite of the apple that keeps going and going and going. And that's what this bill seeks to end. And so the Attorney General supports this and urges its passage, and I will answer any questions at the appropriate time, whether now or later.
Thank you. We're going to go ahead and hold questions till all the proponent conferees have testified, and then we'll circle back with any questions we've got at that time. So if you can hang out and wait, that'd be great. Thank you. Next, we'll hear from Aaron Breitenbach, Deputy District Attorney on behalf of Mark Bennett, District Attorney, 18th Judicial District in the Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, and to all the other members of the committee. Again, I'm Aaron Breitenbach. I'm the Deputy District Attorney in Sedgwick County. I work for Mark Bennett. It's been a couple of years since I've been here in person, but it's a pleasure to be here today. I obviously am here to speak in favor of the bill. I'll defer to Chris on the details because he practices in this area. As you can tell, it is a very unique area of criminal law, which obviously is unique unto itself. So we recognize this conversation can sound a little granular, but the impact it has on the efficiency of the judicial process, of the resources in prosecutor and defense offices is significant. So I'm here to speak in support of the bill generally, but also as through the written testimony, you've seen that our office and KCDA has a friendly amendment, which in speaking with the Attorney General's office is welcomed, to address a subset of that subset, which is not just what their bill addresses, which are the repetitive motions. Ours addresses overlapping motions, where while one is pending, another is filed. And sometimes even while one is pending at the appellate court level, one is refiled at the district court level that may raise the same or conflicting factual issues that are going on at the appellate court level. And it just causes a tremendous amount of uncertainty and really removes any opportunity for finality. And as Chris testified to, that is what this statute attempts to strike, is a balance between providing a clear path to relief for those who are serving an unlawful sentence, who maybe had ineffective counsel and things of that nature, while also providing finality to judgment. Because at some point, there has to be finality in the criminal justice system for obvious reasons. We don't have limitless judicial resources, let alone attorney resources. And I know the committee has heard about the limits to both the defense and prosecution bars that are present here. So our amendment seeks to just address that one overlapping filing issue, which can be folded into this bill doesn't conflict with anything that's in the current bill, so we ask for that. As far as the language in the current bill, the only two thoughts I have is one, legislation like this is very interconnected. So, for example, subsections F and G have amendments. They go together. So if there's some negotiation that happens somewhere along the way, those two both need to stay together. If you take one and not the other, it can create some difficulties. So just be mindful, if any amendment is to occur, that it be seen from that kind of 30,000-foot view and how the parts work together. The second piece, or the second comment I would have, is there's some language about getting these resolved more quickly, and that is obviously an overriding goal here. But there's a reference to an expedited process, and I would just ask that that possibly be amended to something like without undue delay. The only reason why is the word expedited has a special meaning within Supreme Court rules, which could put our office at a tremendous disadvantage where, say, in the Carr case, where defense counsel could have a year or more to write their pleading, an expedited hearing could be 30 days, right? So we would only have 30 days to potentially respond in writing and prepare for that hearing. And there are other examples like that, but I understand the purpose, which is to get things moving, again, to get to finality and to get to relief. And I guess that's my final statement here is, as Chris mentioned, nowhere in this is a stated or even implied goal to limit the substantive rights and relief to those who are serving an unjust sentence. As a prosecutor, as a career prosecutor, I can tell you the last thing I want is for someone to be serving a sentence that is either based on a wrongful conviction or is either somehow too long or illegal. That does no good to the community. It harms the community, and we recognize that. But in order to get to those rightful claims, we have to get rid of the chaff. And we have a lot of chaff in the system, and this bill seeks to address that. Thank you very much, and I'll be ready for questions later.
Thank you. Is there anyone else in the committee meeting room or on WebEx seeking to testify as a proponent conferee? Not seeing anyone, then committee, are there any questions? Yes, Senator Corson.
Thank you, Madam Chair. I'm just really cautious about how we're proceeding in this area because these are death penalty cases. And so there's no ability to go back later and say, oops, we made a mistake. Oops, maybe we should have looked at that a little bit harder. Maybe we should have been a little bit more judicious in our approach. So just in general, I'm really just concerned about how we handle anything involving death penalty cases. My question, though, is about, I think that we've got a really strong bench of judges in Kansas. And I think for the most part, they do a really good job in running their courtrooms and effectively and efficiently and judiciously administering justice. So it seems like when I look, it says right now that current law is that a sentencing court shall not be required to entertain a second or successive motion for similar relief on behalf of the same prisoner. So right now a judge has discretion. I mean, in some of these examples that you're giving about where there's appeal after appeal after appeal, a judge currently has the discretion if he or she thinks that the process is being abused to not entertain a second or successive motion. So I just think that we should I tend to err on the side of saying that we should leave leave it up to these judges to make decisions based on the facts and the circumstances and the law in these particular cases, rather than creating a blanket rule. That's kind of just where I come down, but maybe somebody wants to respond to that and maybe.
Sure, please reintroduce yourself.
Again, Chris Elsliger.
Turn on the
Deputy Solicitor.
microphone first, though. Thank you.
Is it on?
There we
Okay.
go.
Chris Elsliger, a Deputy Solicitor General from the Attorney General's office. The first thing I want to clarify is that this statute does not, it's not just focused on death penalty cases. In fact, this is focused really on the deluge of ordinary criminal cases where the defendants file continuous successive 1507 motions and repetitive motions. The death penalty cases aren't even there yet. And I can tell you as the attorney that is handling 4 different 1507 capital cases, they are getting exceptionally thorough review. Most of them have been going on for about 4 or 5, 6 years in the district court so far, and they're not close to being done. So this is not going to run roughshod over capital defendants at all. The only reference to capital defendants in here is that any appeal from one of these 1507s should go to the Kansas Supreme Court. And that's just a clarification that mirrors the existing capital law in the first instance, where a trial, a person convicted of a capital offense, their appeal goes directly to the Supreme Court. So that just simply lines that up. With respect to the discretion of the judges, I understand your point. I will tell you from actual practice, most of the judges err on the side of, well, we'll set it for a hearing. They don't. They just err on the side of caution themselves, and we end up having multiple repeated motions. I mean, I could tell you story after story of having to hop in my car and drive to Dickinson County, drive to Cherokee County to have a hearing on that lasts about 10 minutes on a motion that really should have never been considered because it's second or successive. But the judges, they tend to use that discretion and err on the side of caution, and it just bogs down the system. If they had more direct guidance that said, you don't have to do this, this should be dismissed unless it hits one of these rare exceptions, that would ease the problem, because judges are human too, and so they also err on the side of caution, and that erring on the side of caution bogs down the system, and that would be my answer to that.
Thank you. Senator Reichman.
Thank you very much, Madam Chair. And this is also for the Attorney General, Solicitor Office, Chris Elizine, or whatever her name is. I'm not sure how to, I just butchered it. I think we're all always concerned that we want to make sure justice is done. I think everybody in the room is going to agree with that. Where I don't understand, or I need to put my head around, how many cases are we talking about? How many times are they appealing? When you're talking about they're going time after time, and how many inmates, do you have any idea, are doing this? I don't think we want to clog up the system. Thank you.
Again, Chris Elsliger, AG's office. It's hundreds, if not thousands. I mean, I don't keep a running total. And Mr. Breitenbach can probably tell you more about Sedgwick County, because they do a phenomenal number of these cases. Our office handles them all around the state, and then I see them again in federal habeas. And it is, I can't overstate it enough. Over years, it's thousands. I mean, these guys that are in prison with lengthy sentences, they have nothing else to do. So they just file motion after motion after motion. I can tell the anecdote of, I've got the 2 individuals, Virgil Bradford and Robert Verge, who murdered 2 people outside of Salina back in 1998. Their direct appeal was finished in the early 2000s, and it's been a running joke in our office. Every year, one or the other of them files some kind of a motion, and I've got one of them is currently on appeal, I think, on his 7th motion, and the other one, I've got a hearing set in Dickinson County in about 2 months on his 6th or 7th such motion. This is not an exaggeration. This is not made up. This is a real problem. When I talked with Mark Bennett and Steve Howell last year about some of their, Johnson County and Sedgwick County district attorneys, and they said one of their biggest headaches is the explosion of repetitive post-conviction motions. And you can trace this really all the way back to 2004 and that Brown decision that allows them to claim ineffective assistance of prior post-conviction motion, which is not a constitutional right. It's not a right that's written into law. It was never in the law prior to that point. The Kansas Supreme Court made it up. And since then, we've had an explosion of these motions, and it is, I'm not exaggerating, it's a real problem. So I hope I answered your question. I'm sorry, I can be pretty emphatic and passionate about this because I live with it, so.
Stay right there. We probably have another question for you. Senator Clays.
Thank you, Madam Chair. And I don't know who to direct the question to exactly. I'm also inclined to separate chaff from the wheat. I think that's a great idea. My concern is that this is in my wheelhouse, and so I don't actually know even what chaff looks like in this case. So I'm just wondering if there is any data that we have that shows how often these recidivist 1507 folks are actually they're actually getting traction with it at some point. So, like, how many? I'm just wondering how many, the hit rate for that, or they actually are getting, there actually is a justice case, after, a dozen motions or something like that, I guess. So, thank you.
Yeah, I'm not aware of any that have gotten traction. Every now and then, I have seen cases where they find ineffective assistance of post-conviction counsel, and they go back for essentially another 1507 proceeding all over again, and they still lose. I've never seen, I don't know of anyone who ever got a conviction reversed on a second or third or fourth such motion.
Yeah, that's what I want to hear. I just want to have an understanding of what we're talking about here, and knowing something like that. Like, if that isn't in fact the case, then yeah, it's a whole lot of chaff. So I appreciate your answer, and if you hear any updates on that, just let us know.
Okay.
Thank you. Committee, any other questions? Not seeing any, then thank you both, gentlemen, for appearing today and your testimony. Appreciate you coming to the Capitol. Next, we're going to hear from opponent conferee Clayton Perkins, Board of Indigence Defense Services. Please introduce yourself and welcome to committee.
Thank you, Chair, and members of the committee for the opportunity to be here today. I am Clayton Perkins. I'm here on behalf of the BIDS Legislative Committee. I am the Chief Attorney at the Capitol Appellate Defender Office, which is an office in Topeka that represents individuals in high complexity appeals from conviction and from habeas proceedings in high complexity cases, including some death sentence cases. I am therefore happy to, at the appropriate time, answer questions pertaining to the death penalty and the issues here. There were some questions that came up from the proponents involving the expedited language there. I think a proponent just asked to change that. My comment generally to that, they were mentioning the complexity of death penalty cases. My office deals in those. They are incredibly complex cases with extensive records. My first case that I looked at had a record on appeal that was 11,000 pages long. It took me about 6 months just to get through thoroughly reviewing the record there. In habeas actions, that record is even longer. The numbers I've heard most recently from our habeas office is their shortest record is 75,000 pages. It takes defense attorneys an extensive time to review those. It takes prosecutors extensive time to review those. We're both zealously and expeditiously working on those cases, but the amount of time that both parties take is generally equal. We file similar numbers of continuances, and it's because these cases are extraordinarily complicated. But I think the bigger concerns about this bill aren't the death penalty cases, though there are concerns there. And I will say my other note on there is the Court of Appeals handles all habeas appeals on the first round under current Kansas law. There are criminal matters that are appealed directly from conviction to the Kansas Supreme Court, but all of those have always gone to the Court of Appeals. So they actually have the real expertise in handling those cases on appeal, which is one of my concerns there. But broadly, this bill impacts more than just death penalty cases. And you're going to hear in a few minutes from Gene Phillips and Tricia Bushnell, who work on wrongful conviction cases. They literally teach classes on wrongful convictions in Kansas habeas process. So I'm going to allow some of the technicalities to fall to them. But what I want to talk about is the right to counsel here. I heard one of the proponents talking about how you have constitutional rights to trial counsel, you have constitutional rights to direct appeal counsel, but trying to narrow out habeas counsel where you only have a statutory right. I think it's a fundamental principle. If you have a right to counsel, be it by statute or the Constitution, people want those attorneys to do their jobs. They want them to provide the minimal effective standards of counsel, that you want them to perform reasonably and work with due diligence. And habeas, what's at issue here, is our primary mechanism for evaluating whether counsel provided constitutional representation at the two prior stages. So without effective habeas counsel, you don't have adequate review of both the constitutional rights in those to counsel there. And my experience here is that we don't see a lot of successive appeals. We don't see a lot of 1507 filings in general. I can follow up after this, but I worked on a report estimating the caseload impact for 1507 counsel for part of our public defense system because we provide that counsel. In 2019, I believe there were around 150 1507 filings statewide. So I don't think there are a tremendous number of these cases happening even in the first filing, let alone in the second. But more importantly, this 1507 exists as our escape valve, as our final checks, as our way of making sure that everyone did their job and justice was done. And speaking from the experience of capital defense, failures happen, and they happen in catastrophic ways, and this is important to correct those failures. Death penalty cases, because that's where my experience is, they are incredibly complicated. They require you to work day and night, hour after hour. They require you to do everything you possibly can on behalf of your client, and they cause stressors, they cause workload issues. I imagine I'm being told my time is near the end, but.
1 minute.
Okay. Attorneys deal with depression, anxiety, drug abuse. Across our industry, it is an issue. Our job is stressful. In death penalty defense, those stressors apply even more thoroughly. They make attorneys question whether or not they are going to kill their client by not doing their job. They make their attorneys question things like, am I going to get my client killed because I went home for dinner with my family rather than work on this case all night? Those stressors build up in catastrophic ways. I know since I have been doing capital work, I have seen 3 different attorneys who did capital work in Kansas who have lost their licenses subsequently to their capital work. I know of 2 attorneys who quit their jobs in capital work because they were dealing with mental breakdowns due to depression, anxiety, and suffering from suicidal ideations brought over by the stress of the workload. I know 2 attorneys who died shortly after quitting capital work from health problems, including one who was suffering from dementia that we realized subsequently that impacted his work. Those breakdowns happen, and I think it is fundamental that we have a system that can correct those, even whatever level they fall at. Thank you.
Thank you. Next, we're going to hear from Gene Phillips, Connell Teaching Professor, Clinical Professor, Director of Clinical Programming, Director Project for Innocence, University of Kansas School of Law, on behalf of Kansas Association of Criminal Defense Lawyers. Please introduce yourself and welcome to committee.
Good morning. My name is Jane Phillips. I'm here to talk to you about my experiences. I do want to emphasize that I am here in my personal capacity, not as the director of the Project for Innocence, and I am representing Kansas Association of Criminal Defense Lawyers. I'm not here on behalf of KU. So I have been doing this work for 26 years, and I do it across the state, and I see review hundreds of habeas petitions in a year and decide which of those habeas petitions we ought to move forward with. There are a number of provisions that are going to actually prevent innocent free people from having access to the courts. Let me begin with the way that our system is set up under 1507 is that individuals file their 1507. Courts do not have to appoint an attorney unless the court can determine that there is, if the court can resolve it from the record below, they don't appoint an attorney. They only appoint an attorney once they decide that that individual cannot have their issues resolved based on the record. Then that attorney is appointed. A couple of things I want to mention about appointment of counsel. We have a dearth of attorneys in this state. There are places in western Kansas that don't even have an attorney in the county. We have places where attorneys from Johnson County are representing people in Colby because we can't get enough attorneys. And so when you talk about appointing counsel, they don't always get the counsel that they perhaps deserve. Two, if the court decides that that 1507 needs to be reviewed, then they appoint an attorney and a hearing is held. Currently, there is discretion with our court. They do not have to assign those second or successive petitions, and I suggest to you that they are in the best position to decide whether or not that second petition resolves in having to be heard. Let me just start with Lamont McIntyre. When the state says that they are not aware of anybody on their second or third or successive petition, that is not true. Lamont McIntyre was charged in 1994 with a double homicide for crimes he did not commit. The first attorney to represent him did not talk to him, did not meet with him, did not have him at the hearing, and presented no evidence. That 1507 hearing lasted 30 minutes. 30 minutes, and it was over. It wasn't until his third petition, where he had an attorney who actually understood the very specific nuances and niches of 1507 litigation, that they were able to establish his innocence. And because of that, Lamont is free today. If we had these standards in place, he would not receive assistance. He would not have been freed. He would have no recourse. Second is that standard for successive petitions that Mr. Aislinger said comes from the federal district or federal statutes. I understand that this is a really niche area of law that many of you maybe are not familiar with, but the way the system is set up is that 1507 is the remedy in state courts. Federal court gives all kinds of deference to state court. That's where federal habeas comes in, and I do a lot of federal habeas litigation as well. And federal habeas defers to state court. They want the states to hear them first. That's why they have the strict standards for successive petitions in federal court, because they're assuming that the state courts are taking care of them. If we try to mimic, we are now putting stopgap measures in place that would prohibit that first initial application or ability to access the state courts. That's not an appropriate standard for this court to adopt. First, it would require that new evidence could be evidence that could not have been found previously. Let me remind you about Lamont. All of the witnesses were available at the time of trial and at the time of the first hearing. All of them. But nobody bothered to go talk to them. If we had this standard in place, Lamont would not satisfy the second or successive petition standard. They also provide that you have to have a constitutional violation, and they increase the standard to clear and convincing evidence for what constitutes new evidence. Again, those are standards that the federal court adopts because they are not there to provide for resolution of innocence in those cases. They're expecting that that is done at the state court level first, right? So they have different provisions in place. We have statutes, or we have a provision in the Kansas statute that says, if there is a reasonable probability that in light of the new evidence, the individual would have been acquitted by a jury, that gets you into court if you're outside the statute of limitations. But now they're telling us we can get into court, but we have a stronger statute. We would be prohibited, right, under the new standard. We've got different changes in what constitutes reasonable suspicion, or what constitutes new evidence. And I encourage you not to apply clear and convincing. That is a very high standard. IAC of counsel, let's go back to Lamont. His attorney did not talk to Lamont, did not present evidence for Lamont, did nothing for Lamont. And now we're saying that you can't come back and challenge that. And I want to talk about State versus Brown for a minute. State versus Brown did not create, out of whole cloth, a constitutional right to the effective assistance of counsel. Brown very specifically says there is no constitutional right to the effective assistance of counsel in a 1507. But Brown says under our statutes, under Supreme Court Rule 183 in our statutes, once you're entitled to counsel, you have the right to have a competent attorney. Otherwise, your right to counsel is meaningless. And that's exactly what happened to Lamont. I want to encourage you to think about what this will do to people who are innocent. We've had 20 exonerations in the last 20 years in Kansas. Please pay attention and let those people have access to justice. Trust our courts to do their job. There are not thousands and thousands and thousands of petitions that are being filed. I would look for those numbers. I don't believe that they exist.
Thank you. Next, we will hear from Tricia Rojo Bushnell, Executive Director, Midwest Innocence Project. Please introduce yourself and welcome to committee.
Good morning, everyone. My name is Tricia Rojo Bushnell. I'm the Executive Director of the Midwest Innocence Project. As you heard from Mr. Perkins, I also have taught state post-conviction and federal habeas classes in a number of law schools. And I'm here today specifically to talk about how this bill will impact the ability of our clients, who are innocent people seeking to be released from prison, to access justice. You know, I heard from the proponents that the concern is about finality. And certainly we can talk about finality, but what this bill does is it puts finality over fairness. Because what we're looking at is the inability of someone to access the court when they need it. So one of the comments that was made was that how many people have successive petitions. In order to get to our office, an individual has to have finished their direct appeal and typically has finished all of their other appeals. So anything we ever file is a successive petition. And to put some emphasis on that, my office, we work in 5 states. We have 941 applicants waiting for assistance right now with only 5 lawyers to review them. It is impossible for us to get in on a timely review without it being a successive petition. And in fact, some of our clients, like Kevin Strickland, who was exonerated in 2021 out of Kansas City, had filed so many successive petitions, and the Missouri courts had told him, we're not even going to hear anymore. We're so mad about it. And ultimately, in his case, the prosecutor, once presented with the evidence we had, agreed he was innocent and moved to overturn his conviction. These cases can take a long time. And the reason for that is because the amount of investigation and factual need is extensive. And unfortunately, as designed, this will foreclose that. One of the things that SB 60 does is it says that in order to have a successive petition, you must have new evidence that could not have been found through due diligence previously. What this means is if you have an innocent person who, if they had had competent counsel, could have proven their innocence at the time of trial, but they did not receive competent counsel. So, for example, in the case of our client, Ricky Kidd, they didn't have the attorney who went out and found his great alibi evidence that he had been in a sheriff's department at the time of a crime. That person is now precluded from entering later on a successive petition. Because in Ricky Kidd's case, his trial counsel didn't present that evidence, and his post-conviction counsel didn't present that evidence. And so when he went to federal court, which does have this, the 8th Circuit, which is what he's in, we're in the 10th Circuit, is the only circuit in the US that says you have to have new evidence that could not have been found by due diligence. The court said, yeah, this is great evidence. I believe this could show his innocence, but it could have been found before, and they denied him relief. The only reason that Ricky came home 8 years later was because Missouri's state process allowed for what is the US Supreme Court process, where new evidence is evidence that wasn't previously presented, evidence a jury didn't hear, not evidence that could have been presented but wasn't. And so this is taking us to a place where the states can't reach and provide that relief, and the federal courts aren't going to be able to because they're going to rely on the courts below. Another issue that I've heard discussed is that this would reduce the number of filings, and I will just tell you in all honesty, it won't. People who are incarcerated are going to file regardless of whatever the law is. It's a fact. It's a fact we know from when federal habeas corpus in 1996 was changed on the Anti-Terrorism and Effective Death Penalty Act. They said no successive petitions there, but they did provide a lot of outlets that this would eliminate. The filing number went up after that in 1996. More people filed. What changes is we get in fights about whether or not we should be in court, what the process is, the procedure, and not about the merits of the issues. So actually, case resolution takes longer. In the case of Ricky Kidd, we fought for years about whether or not we had the right to be in court, right? And not about whether the evidence we're presenting has merits. And so we can resolve things more quickly if we say, let's just look at it. Let's not argue about should we be here or not. Let's just look, and if it doesn't matter, then we're done. And in those cases, if there's no merits in what's presented in the filing, the case is immediately dismissed even without a hearing. That goes even for first in cases that are timely filed. Cedric Warren was exonerated in December. That was a timely filed post-conviction here in Kansas in Wyandotte County. We had all of the evidence, we presented it, and the district attorney still fought us from even getting a hearing, and it took us another year to get an evidentiary hearing on the argument of should we be in court, and that was for a timely filed petition. So what happens was when we say you can't have these successes is we just get in longer arguments about whether or not we should be in court. Finally, even a state post-conviction, again, when timely filed, can take a long time. I got into this work in 2006 when I was a law student, and I started working on the case of a man named Emmanuel Gissendanner. He was a capital case out of Alabama, and I was working on his post-conviction, and we filed a timely post-conviction in 2006. In 2019, we finally resolved that state post-conviction, and the resolution is Emmanuel Gissendanner is a free man today. When we try to rush something, we elevate finality over fairness. These are important consequences. This is someone's unique individual liberty interest. There is no higher interest than whether you are free or whether you have your life. And we should take that very seriously when we allow people to have access to those systems. I'll take any questions if folks have them.
Thank you. Are there any other persons in the committee meeting room or on WebEx wishing to testify in opposition to Senate Bill 60? Not seeing any, then committee want to also draw your attention to opponent written-only testimony at your desk from Rebecca Woodman. And with that then, any questions? Senator Reichman.
Thank you very much, Madam Chair. And I'd like to address this to Gene Phillips, and thank you for your testimony. Now, wasn't you in my office with Lamont? Oh, you were not. Okay. There was another, Lamont was in my office for about an hour, right, with a few other people when he was up here, and I was talking to him.
Right. That was not.
Please reintroduce yourself.
I'm sorry, I'm Jean Phillips.
Okay.
I was not
And who are
present
you
at
with
that meeting.
again?
I'm with the Kansas Association of Criminal Defense Attorneys.
Okay.
Thank you. Just making sure our record is
Yeah, sorry.
clear.
Okay, thank you. His case was quite compelling, okay, and he was here about something else, but I'd like to have you, I mean, we all want justice, and we want people to have, you know, fair going through appeals and so on. The proponents was talking about there's just too many, you know, they keep on filing and filing. But I would like to have you explain to me again why this particular bill would stop people like Lamont from get a chance to become free. Thank you.
On the second page of the bill, under subsection 1B, where it defines when you can have a second or successive petition, it states that you have to have newly discovered evidence that could not have been found with due diligence. In Lamont's case, the evidence was available. The witnesses were there. if the attorney the first time around who was appointed to represent Lamont in the first 1507 petition, if he had done his due diligence and gone out and talked to the same witnesses that were presented at the third 1507 petition, that evidence could have been presented. Under the new statute, the way the Senate Bill 60, it would prohibit Lamont from presenting that testimony because it could have been presented previously. And when you take discretion away from the court and you say the court cannot, then the court has no discretion to actually entertain and say, okay, maybe this third petition we ought to take seriously. You'd take it completely out of their hands, and you would prohibit Lamont because all of the witnesses that were testified to and the forensic evidence was available at the time of the first 1507 petition. And when you take away the ability to challenge that first attorney was not competent, Lamont's really left with no remedy. He can't get in because the evidence could have been presented the first time around, and he can't challenge the representation of the first attorney who didn't talk to him, didn't have him at the hearing, didn't present any evidence, and did no investigation.
Thank you.
Thank you. Senator Klemp.
Thank you, Madam Chair. So we've heard opponents with Ms. Phillips and Bushnell. I do have a question. Not that we need to litigate it here today, but from Deputy Solicitor General, because there's some specific differences in how they both view the what we're being asked to do here. So I wouldn't mind getting his opinion on this, especially on the Lamont case, which is, it seems to be horrific. But that being said, and I'd like him to weigh in on this.
We don't usually call back up proponents once we've asked questions, but I'll allow that. So thank you. Yes, please reintroduce yourself. Thank you.
I'm Chris Elslager, Deputy Solicitor General. I'm sorry, you'll have to ask me the question again so I make sure I understand what your question is.
So you mentioned that there were thousands or many cases. It seems like with the discrepancy from what we're hearing, we should be able to have that data, or there should be some information on how many cases we're actually talking about and how many were actually successful at the end, just so we can understand that. But there's some significant cases that were successful at the end with the Wyandotte County case. But I wouldn't mind, sorry, that noise. The questions from, or the comments from the opponents were different than your perspective. I didn't know if you had any additional color to add to that, just to help with our own edification on this topic.
Okay. First, as far as the numbers go, I don't know. I mean, perhaps the Office of Judicial Administration might keep those stats. I don't know. I'm just kind of shooting from the hip based on experience, and it's probably hundreds of cases a year, and then they pile up into thousands eventually, right? But there's not thousands every year, but it's probably hundreds, but none of these things get finished quickly. And as far as the Lamont McIntyre case goes, I was not involved in that case. I can't really comment on that, but I would say that is the very rare exception, and we think that the bill, that SB 60 would still allow for someone who is actually innocent to make their case. And as I said at the beginning, this only affects the second and successive petitions. In the law, the way to you make your case at trial. That's where you should make your case. And then if you fail there and there's an error, direct appeal is the most effective. That's when most errors are found, and that's when reversals happen. When you get to the 1507, the habeas corpus realm, the odds of success go way down. I mean, they're very rarely successful. But then you still get an appeal from that. And then, so what this bill does, this only addresses after a person has had those multiple bites at the apple to provide some finality. And there are specific carve-outs within the bill for those cases where counsel completely abandons their client, and for those cases where newly discovered evidence or a significant change in the law would undermine the conviction, right? So those carve-outs are there. And now I've rambled, so I don't know if I've completely answered your question. I think there was one last part of it, or did I answer everything?
You did fine, thank you. And thank you for the process reminder. Thank you.
Thank you. Senator Clays.
Thank you, Madam Chair. And Senator Klemp actually made me think of something here. I was thinking that, honestly, I would kind of like to see a friendly Oxford-style debate between these folks on this issue. If I could talk to the professor again, that would be great. So thank you for coming today, and you added a lot of valuable insight into this issue, and I appreciate that. Obviously you're well schooled on these matters, and you mentioned, that you can get a little nichey, and I'll just admit that all areas of this legal stuff is nichey to me. So, but my question is there, in your opinion, not speaking directly to this legislation necessarily, but it is what we have before us, is there, in your mind, a way to decrease, it was termed the chafe, so I'll just keep using that term, the chafe, from the wheat? Is there maybe a number of 1507s that you would feel like, well, that is a little ridiculous, or is there a way to limit it so that we can get down to the ones that have more merit, like maybe limiting them to 3 a year or something like that? Again, this isn't my area, so if the question sounds ignorant, I apologize, but I'm just trying to get a sense of the landscape here because I'm not familiar with it, and I definitely find your opinion very valuable. Thank you.
Please introduce yourself again. Thank you.
Jean Phillips on behalf of the Kansas Association of Criminal Defense Lawyers. So I want to start by saying you have your trial, and you're right, Mr. Aislinger is right, you have a direct appeal, but you cannot raise these issues on direct appeal. The issues that are raised in a 1507 of ineffective assistance of counsel are barred from the direct appeal because you can only raise issues that were presented during the trial. So if your attorney doesn't present evidence, doesn't make arguments, you can't raise that on direct appeal. The very first opportunity that you have to challenge the effectiveness of your attorney, to challenge the new evidence, is on a 1507 for the first time, right? If you don't have an attorney who properly represents you in that 1507, then the evidence still doesn't get presented, and the objections and the arguments are still not made. The only recourse that person has is to try to find someone to represent them in the second petition, and then you're going to be barred because you could have presented that below. So to say we have safety valves are not actually true. So in terms of separating the wheat from the chaff, our statutes have relied upon the district courts to do that. My experience is different from Mr. Aislinger's. I've been doing this for 26 years. We do this across the state. I represent people in all corners of the state, and I've been everywhere. Maybe one of the advantages of COVID is that we can now do these 10-minute Zooms. We do these hearings by Zoom sometimes, so we don't have to travel to Cherokee County for a 10-minute hearing. But we still have to do those, right? But my experience is that the district court is very good at saying no. In fact, I have to fight sometimes just to get a hearing so that I can present evidence. We've had an individual, I want you to step back and think about the people who are incarcerated don't have the same resources that the rest of us do. And so I've had clients who have had new evidence come up, who have filed petitions on that new evidence. They don't get appointed an attorney. They don't get a hearing. They come to me, and it's their second or third time, and they still haven't had an opportunity to present that evidence, right? So when we're talking about separating wheat from the chaff, we have to be really careful, and I think we have to rely on our bench. And my experience is that we have a pretty good bench. And they're very good at telling me, no, Ms. Phillips, we're not going to hear that. No, we're not giving you a hearing. I have to fight for that stuff. My experience is very different than Mr. Aislinger's, and I've been doing this for a long time across the state. I don't know if that answers your question.
It mostly does, but I just want to get a sense from you. First of all, are you willing to even concede the point that maybe there are folks that are maybe bad actors that are engaging in this process, maybe as either a way to get back at the system, or maybe it's just a lottery ticket. Maybe they feel like they're going to get lucky.
So yes, I will admit that there are people who are repeat filers. And we have those people who apply for assistance and we tell them no. We're pretty particular about what we file on. yes, there are people who will repeatedly file, but my experience has been that the court is pretty good about denying them. And maybe that's different from Mr. Aislinger's experience, but my experience is that the court is really good about saying no to these folks. So when I get people who have had their second or third petition and they're applying to my office, I look at those prior, I can pull up their prior records, and it often is just no, 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 no. They're pretty straightforward denials. And I understand that that can take some resources, but I don't think we can throw away, my answer would be, we don't throw away the wheat from the chaff, right? We're throwing away good cases at the expense of trying to have finality and preventing people from getting access to the courts.
Thank you. Senator Rose?
Thank you, Madam Chair. And any one of the opponents can answer this question. Was Mr. McIntyre's first attorney a bids attorney?
Hello, my name is Tricia Rojo Bushnell. I'm the executive director of the Midwest Innocence Project. I was also one of Lamont McIntyre's attorneys. So Mr. McIntyre's case was out of Wyandotte County, which did not have a bids office, and it was an appointed counsel. Okay.
We've been briefed in this committee on the shortage of bids attorneys, and there's been some interest expressed by some of having the state legislature pay for student loan debt, law school debt for attorneys to go to rural Kansas. Would it be a better use of taxpayer money to have more accurate convictions if instead of using taxpayer money to pay off student loan debt for attorneys, if we paid defense attorneys a higher wage than what we currently are?
So I can't speak as to what is the best recruiting method for the bids attorneys, and maybe Mr. Perkins has comments on that, but what I can say is certainly I would love to work myself out of a job. And I know that for a fact, when people have competent counsel at trial who perform adequately, who do all of the work that they're supposed to do, I don't need to come along later, right? And so certainly that does reduce the number of other filings with merit down the line.
Guys, follow up.
Can I just add one comment to that? Not only
Sure.
do we
Can
need
you
to
identify
have-
yourself again,
Oh, sorry,
please?
I'm
Thank you.
sorry, I'm so bad at that. Jean Phillips on behalf of Kansas Association of Criminal Defense Attorneys. I'm just going to add to that not only do we need to have better defense, well, we need to have defense attorneys across the state, and we do have a dearth of attorneys across the state. And I know that there are organizations that are working. There's an Access to Justice through the Kansas Supreme Court that I'm helping them put together materials on to try and to get people to go to Western Kansas. But I want to remind you that you also need to have competent, effective 1507 counsel. Because if you don't, then you're running into problems and people like Lamont. But yeah, we need to have attorneys across the state that are willing to do these cases and do them effectively. And actually, our office has started taking those appointed cases, which is really new for us. But BIDS has been begging, right? They just don't have enough attorneys.
Thank you. Senator Bowser.
Thank you, Madam Chair. And I think maybe this question will go to Professor Phillips, please. I'm reading the Attorney General's opinion here, and I understand that today we're here because of the 2004 Brown versus Kansas case. And I'll preface this question a little bit with I often do not agree with our Kansas Supreme Court, but in that ruling, the Attorney General claims that it interfered with the statutory right to effective assistance of counsel in post-conviction proceedings, despite no constitutional or explicit statutory right existing, and that the Brown case overruled a prior precedent set in Robinson versus the state in 1989, which the Attorney General believes correctly held that such a right did not exist. So what happened before 2004? Were there 1507 appeals allowed? And are we at such a, do we have so many incompetent attorneys that we really need 3 and 4 trials to determine someone's innocent or guilt? Thank you.
So prior to Brown, and actually in Brown, I want to make a distinction. Gene Phillips, on behalf of the Kansas Association of Criminal Defense Attorneys, I want to make a distinction here. So, and prior to Brown, the Kansas Supreme Court has said you don't have a constitutional Sixth Amendment right to the effective assistance of counsel like you do at a trial, because this is considered a civil collateral attack on your conviction. Brown didn't change that. Brown said you don't have a constitutional Sixth Amendment right to counsel. What Brown said is that when our statutes and our Kansas Supreme Court rules require that an attorney be appointed in a 1507 because you can't resolve the issues based upon the trial record, you need to hear some more evidence, that when you appoint an attorney in those circumstances, that attorney has to have some level of competence. Otherwise, the appointment of that attorney becomes meaningless. It has to be more than just a warm body who stands up and says, you should reverse a conviction, right? That's what Brown says. So Brown pulls from Supreme Court law and from the statutes that say you're entitled to the appointment of counsel to say that has to mean something, so that you can't be the attorney in Lamont's case where you just don't talk to the client, don't investigate. And I have to tell you, it's not just in Lamont's case. There was a period of time out of Sedgwick County, and I'm not going to name names, but there was an attorney who would stand up. He got appointed, he got his $1,000 or $500 from bids, and he would stand up and he would read the petition, and the court would say denied, because you have to prove up your claims, right? You can't just say there's new evidence out there. You have to show what that new evidence is. You have to prove that you have a valid claim. And when attorneys just stand up and just say, well, this is his issues, judge, and the judge's like, you got anything else? And the person says no, denied. And that's not acceptable. We've had cases where we've argued that that's not competent counsel. We've won a few of those, right? But that's the point, is if you do, and this provision would prevent us from challenging that. It would prevent us from going back and saying the attorney who just stood there and did nothing is now going to be binding.
Thank you. We're running out of time here. I do have a question, but I'll take it offline. And with that, then, if we don't have any other questions, I think we've had a thorough discussion from both sides and appreciate the testimony today and you appearing in committee. With that, we will close the hearing on Senate Bill 60. Committee, to keep us on schedule as best we can, I would like to work one bill that I don't think we have any amendments coming on, and it's the bill that we heard just yesterday, so it should be fresh in your memory. Senate Bill 135, providing precedents of child-related orders issued under the Protection from Abuse Act. So if we'll have a bill brief from the reviser.
Thank you, Madam Chair. Senate Bill 135 does provide that precedence for those child-related orders. So it provides to what extent a PFA order can modify a legal custody or parenting time order.
Thank you. Committee, any questions for the reviser or any discussion? And I will entertain a motion. Is there a motion? Yes, Senator Corson.
Thank you, Madam Chair. I would move that the Senate Judiciary pass out Senate Bill 135 favorably for passage.
Thank you. And a second from Senator Clays. Are we thinking that this is of the nature that it's non-controversial and could maybe be placed on the consent calendar? Just a thought. So do you want to amend your motion, Senator Corson?
Yes, Madam Chair, with the second's permission, I'd be glad to amend the motion. So I'd like to make an amended motion to pass out from the Senate Judiciary Committee Senate Bill 135 favorably for passage and recommend placement on the consent calendar given its non-controversial nature.
Thank you. And we do have the withdrawal of the second and a new second made to the motion. Any discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Thank you, committee, staff, and our conferees, and those following along in the committee meeting room and online. With that, then, the meeting is adjourned.